A loved one has died and they own a house. Do I need to go to probate? Hi, I'm Darren Findling of the Probate Pro, and we're going to cover this very common topic about somebody who owns a piece of real estate and dies. First, let's talk about the situations in which you can avoid probate. There's no need for probate. The first is when the house is owned by two people or more as joint tenants. What that means is that there's a survivorship right. The co-joint tenant will then receive the property by operation of law without the need for probate. So even if there's a will that references how the asset should pass, the joint ownership controls. Another situation is a husband and wife. If they own the property as husband and wife, then the spouse inherits the property at death. Now, if they own the property, for example, as John Doe, a married man, that's quite different. That is just simply a reflection of whether they're married or not, but it does not create what we call tenants by entirety. So that would require probate. In addition, a ladybird deed. A ladybird deed is a deed which is an enhanced life estate, and that deed is done so that upon death, you avoid probate altogether. The named beneficiaries on the deed can receive the property by simply recording the death certificate. No need for probate at all. The next question that comes up is, well, I have a will, and the will says that I get the property. Does that mean that I can avoid probate? No. In fact, a will is simply the playbook, the guide of how the property will be distributed pursuant to the probate process. The will does not circumvent probate, but rather guides through probate. People often confuse the fact that they have a will that says that they receive a property and they think that they've just become the owner. And that's not the case at all. The probate process is required. And that begins by the filing of a petition or application for probate, asking the court to appoint a personal representative so that they can have the legal authority to administer the estate. That really begins the process, a process that can take months for purposes of administering the estate, potentially selling it if that's the intention, or if the family is going to inherit it, the probate process will then allow for a fiduciary deed at the conclusion for them to receive ownership of the property. So there are certain circumstances which probate is required and certain circumstances where probate is avoided. And the key to making that determination is understanding how the property is owned as of the date of death. We typically advise people to go to the Register of Deeds and do a title search to understand how the property is owned, whether there is a joint tenancy deed, a ladybird deed, a tenants by entirety or husband and wife deed, or whether the property was owned by the individual in their individual name. Now, for many people, this can be quite complicated and technical, and we don't expect everyone to simply understand the nuances of the intersection between probate and ownership of realty. So that's what lawyers are for. And we strongly urge you to work with a skilled, competent probate practitioner that can guide you through this process. If you have questions about this matter or any probate or trust or ownership related issue, visit us at the Probate Pro or call us at 1-833-PROBATE.